Before you, Mr. Stephen Dwayne Hutchinson. He's here on warrant number 2021-845, 203-0050. He was charged with possession of meth. Your Honor, just a little background on this case. Mr. Hutchinson was asked to appear. First appearance was back in October of 2021. He failed to appear, and subsequently a bench warrant was issued for his arrest. He was picked up later on that bench warrant. Since he was picked up on this bench warrant, he did apply for the public defender's office. He was appointed a public defender for the Williamsburg County Public Defender's Office, but there was a conflict because both lawyers here already are representing his co-defendants in the matter. He was advised that he would just be reassigned to a new lawyer, but he has indicated to the court that he wishes now to represent himself. So we brought him in before you, Your Honor, to give him his Miranda warnings.
And he's charged with just possession of meth.
That's right, Your Honor.
And how long has he been in jail? How long have you been in jail?
Almost 30 years.
And you want to represent yourself?
Yes, sir.
You ever done that before?
No, sir.
So you had any training at all?
No, sir.
You understand? I mean, you have a constitutional right to represent yourself. And all I'm trying to determine is to be sure you understand what that means.
Yes, sir.
Because if you go to trial, the judge can't help you. You're held by the same rules. You know, you may have defenses that you won't even recognize because you don't have any legal training. So it's really dangerous to represent yourself. You understand? And if you can't afford a lawyer, I'll appoint one to represent you.
Yes, sir.
So do you want me to appoint a lawyer or do you want to go by yourself? Do you intend to plead guilty to these charges or do you intend to go to trial on these charges?
I plead guilty. Actually, I would like to be able to talk to the solicitor.
I can arrange that.
That's the response.
All right, well, I'll give you a few minutes to talk to solicitor.
Thank you, sir.
Mr. Stephen Dwayne Hutchinson. He's here on an indictment 2022 GS 45-0109. He is waiving presentment of that indictment to the grand jury, as well as waiving the drug analysis of the drug that's found in his possession of meth case. Your Honor, he has indicated that he's going to plead guilty to this charge, and the state is recommending a conditional discharge sentence.
Okay. Mr. Hutchinson, and part of the conditional discharge is if you complete the term of probation, I'll put you on this case goes away, your record is expunged.
Yes, sir.
Do you have a prior record?
I do.
The SLED may not expunge it.
But I don't have a drug record.
Okay.
I have no drug record.
Okay. All right. So and the way this works is, I'll go over your rights with you, set out all the stuff you plead, and I'll put you on a term of probation. If you make it, it all goes away. If you don't, you come back and look at it 3 years, you understand?
Yes, sir.
Is anybody threatening you in any way other than what you negotiated with the solicitor and promised you?
Yes, sir.
You under the influence of alcohol or drugs today?
Yes, sir.
You got any mental disease?
Yes, sir.
You have a right to remain silent. You have a right to a jury trial where you can confront witnesses and cross-examine witnesses and subpoena witnesses to testify on your behalf. You understand?
Yes, sir.
Okay. Tell me a little bit about the facts, sir.
Well, actually.
No, well, let her tell.
Oh, I'm sorry.
Let me say, I want to hear her side, then I'll hear your side.
Your Honor, on August 31st, 2021, officers with the King Street Police Department, Sergeant Coker was on patrol near Hampton Street, which is the town limits of King Street, South Carolina, when he observed a silver Shelby van driving left in the center lane. He activated his blue lights to make a traffic stop on their vehicle. When he approached the driver's side and made contact with the driver, who identified himself as the co-defendant, Mr. James Duke, he stopped Sergeant Coker asked Mr. Duke for his license, registration, proof of insurance, and to step outside the vehicle so he could explain the reason for the stop. As Mr. Duke was exiting the vehicle, Sergeant Coker observed a clear bag containing a green leafy substance beside the driver's seat. Sergeant Coker explained the reason for the stop and asked Mr. Duke if he was the owner of the vehicle. Mr. Duke stated he was. Sergeant Coker then asked Mr. Duke if there was anything illegal in the vehicle. He stated there was not. Sergeant Coker asked Mr. James Duke about the bag containing the leafy substance. He stated that he did not know anything about that, and that's when he conducted a pat search of Mr. Duke. Sergeant Coker then called for backup and asked the other occupants of the vehicle to step out, and the other occupants were his brother, Mr. Terry Duke, and Mr. Stephen Hutchinson. They were detained for officer safety, and they were all granted Miranda rights. Sergeant Coker began the probable cause search of the vehicle, removed the clear bag with the leafy substance that was only in the jeans used. As he continued his search, he found a pill bottle in between the two front seats with the label removed. And inside that pill bottle was a small blue bag containing a clear crystal-like substance. And this bottle was in the area that was easily accessed by all occupants. They asked who did the pill bottle belong to. None of the occupants claimed ownership of the drugs. The drugs were sent off for testing. We do not have the results back yet. So it was placed in the best kit and there's been an analysis performed. As I stated, Mr. Hutchinson has waived the drug testing of the meth. He said that it is what it is. And the state also, want to put on the record, he stated that if he does the probationary sentence, he lives in Lake City, but he would like the probation to remain here in Williamsburg County.
Okay, that right, Mr. Judge?
Yes, sir.
Okay. How long you been in jail?
Since 30.
Since you've been in jail that long, I'll give you 3 months probation. And hope you make it. If you do, it'll all go away. You just got a report now.
And just on the Cothran record, too, he was put on the bench warrant, he was on the bench of the bench warrant.
Yeah, you got to let your man. What do you want me to write that on the part?
Put it on the sentence sheet, the bitch wants it.
But I don't have a sentence. I have this discharge sheet. What you want to put on that?
You put it on that.
Okay. And if you don't show up for probation, all you got to do is show up for 40, you also get 2 3 months probation. Okay.
Thank you.
Yeah.
Yeah.
You did a good job up there. Please go on. Okay.
May it please the court?
Yes, sir.
Your Honor, before you is Laura Yolanda McLean. She's before you on 1 count of trespass after notice and 2 counts of shoplifting. This case, just a little bit of procedural history on this case. It has been sent to the solicitor's office, not over subsequent shoplifting offense. She's been adopted for the county public defender's office. Here today, Mr. Barr has a motion. I think it's 2 motions related to the bond competency. And I can just read the ticket number into the record because the case is about it. It's 2021 A45203 0067 and 66. And then another charge of 8102 P103 7224. Again, these cases could be sent to us by the magistrate court. It's my understanding that she's in jail now on failure to appear bench warrant.
Okay.
Thank you, Mr. Court, Your Honor. Before you is Ms. Laura McLean. As the state has indicated, this case has a really different set of procedural facts. It was a magistrate case. Mr. McLean was brought in on a failure to appear warrant based on those charges. It was then moved up here to general sessions. I believe at this point, Your Honor, our goal is to get her released, but I do believe, Your Honor, based on my knowledge of facts and my discussion with Ms. McLean, there is a need for a evaluation of competency of some type. However, in the interim, we would ask for her to be released on her own reconnaissance until we can have that evaluation ordered and fall through.
Okay.
And I believe the state's in
That's
agreement with that.
Yes, Your Honor, we want to make sure that the rule regarding bench warrants is complied with as far as them getting the bonds and supposed to, and that if she needs competency evaluation, that needs to be.
Okay. So, how come she hasn't been tried in national court?
Part of the reason for that, Your Honor, is we did have an issue of locating Ms. McLean to get her to magistrate court for the appearances. When they were.
And with a normal procedure is they don't try in the absence of magistrate court, they don't appear. I mean, normally what happens, she would have been tried and convicted in magistrate court and bench warrant been issued. That is not what happened here.
That is not what happened, Your Honor. I will tell you that there was in the time that Ms. McLean picked up the charge and had her first appearance, there was a change in counsel, and I came into this case probably within the last 60 days. And in those time periods, we had 2 hearings, or 2 appearances that Ms. McQueen was not there. On the second appearance is when the failure to appear warrant was issued. At that point, the case was then moved up to this court. The issues that I have, Your Honor, is that I believe that there needs to be an evaluation for Ms. McQueen. I don't believe she's capable of entering into a plea. I wouldn't be comfortable with pushing her into that.
I understand. I'm just, on a normal scenario, if somebody been arrested or given a ticket or given a warrant to appear in magistrate court for shoplifting, petty larceny, and they don't appear, normally the magistrate tries them in their absence. If they're found guilty of insurance issues, they're found not guilty of not. And so I was just, that not the common practice here in magistrate court. They don't try people in their absence. And I'm not first appearance, they in a magistrate court.
I believe, Your Honor, and I don't want to speak for the magistrate, but I believe that the fact of the change in counsel may have contributed to them not going forward with trying her in her absence.
And I think there was a moratorium, I don't know if it's continued because of the coronavirus on TIAs in general. I don't know, again, I don't know that specifically in this case. I just speculate.
And one thing I want to correct, just real quick, just information I just got, Your Honor. I believe that based on what I'm getting from my staff here is that this has been this is not Mr. McQueen's first arrest on these charges, and I believe that the magistrate and we would have to consult with them. But this is not the first time. She has been tried in her absence in the past, but in this case, for whatever reason, she was not tried, and leads us to where we are today.
Okay. My only question is, I'm trying not to kick this can down the road without, if I grant your motion, and we do a Blair evaluation and a PR, if she gets out, does she have a place to live? How is she going to be available for the evaluation? And how is she going to know to be back in court if you have some concerns that she's not confidently guilty? And how is she going to be confidently know she's supposed to be somewhere?
That's a fair point, Your Honor, and it's the point I believe that continually puts us back in.
And so, if we are to put, if I get her out, and we do evaluation, how she can get to the evaluation? How she gonna know how to get to the evaluation and just confine her? Does she have family or anywhere she lives? Is she on the street?
I live in Rocktown with a gentleman named Vance. He's kind of like affiliated with the court, and he drives in a silver car, and he lives like on Greenlee Road, all the way around the corner with a friend named John. I call him John, but his last name is Al.
Your Honor, part of, one of the things, Your Honor, we are concerned about is that Ms. McQueen may not have a place to go. However, based on the nature of the charges, she also will end up doing more time than the charges calls for.
Okay. And if I give her a PR bond, if we are an evaluation, do you have contact with her? How is she gonna know how to get to the evaluation? How is she gonna get it? They gonna take it to Columbia, they gonna do it locally? Does anybody know?
Normally in the process they go to Columbia, but we are going to be reaching out to a separate matter to see if they would entertain doing a virtual visit, because we do have other folks that are in the same situation that need to be evaluated.
Okay. How long has she been in jail on these charges?
On the failure to appear warrant, I believe she's been in, perspective, it's been, since our last term of court, I believe she's been in for about three full weeks on the failure to appear warrant.
What about when she first arrested the shopper?
She was bonded out, I believe she was bonded out.
Who bonded her out?
She bonded that one next day.
Next day.
I can't read the specifics on it.
What was that? It looks like it was a $2,100 surety bond, and so she was arrested on the 2nd of November of last year, and she bonded out on the 3rd.
So the bond, who is the bond?
I bonded out,
Well, it seems to me we better off having a bondsman locate her than a PL bond and let the bench one. If I got a bondsman who has some contact with her, then he can help find her to get her to the evaluation versus I just give her a PL bond. Nobody's going to be in contact with her.
Freedom Bell's bonding, they would have, her name is Melissa. She would have the best information because I stayed in county exactly 4 months before I was able to be released from that date. I was arrested first in November, and the reason for it because I stayed 30 days, 4 years. The magistrate let me out, and before Christmas, around the 7th, I got arrested again in Williamsburg County at a Dollar General store, a yellow store, preferably by the same officer that was, in relation to me. And last name was Palmer, and the cashier name was Linda.
How did she come up with the money to hire bond? I mean, the bond, I'm just worried about if she got put her back on the street, how she ever gonna know to appear anywhere else. But at least I got a bond to come and tell her to be in court tomorrow. Do you think you gonna have enough contact, you gonna be able to get her out?
I believe the bondsman, Your Honor, if I go back to if I can go back to that last appearance, and I believe it is Freedom Bell Bonds was her bondsman, and I know that Judge, I believe that Judge, I want to say it was Judge Schrader's put them on notice about her, which is why we were had some luck in getting some of the folks in, but I believe it was Freedom Bell Bonds.
What y'all want me to do? I'll be glad to sign the well if it's an issue, but I don't know how we can get her there. And it's I can lift the bench more, I can give her, I got to lift the bench more either way. I can give her. So I don't need to give her a PL bond, she's already bonded out. I didn't think she was bonded out.
She's bonded out. We would like to, I believe we discussed her, we would like to move forward. I just have concerns about Ms. McLean, her ability to be able to enter freely and voluntarily into a guilty plea.
If I lift the bench more, I'll get to it aware. What notice is she going to have to be aware when? I need to give her some notice. She has to be either back in court somewhere on a particular date if I'm lifting the benchmark. Usually, it's supposed to have to be to lift the benchmark, but when you want them back, she gotta have some date this person's lifting it. She'll never know when to be back where. How you don't want me to do that?
The only thing that the clerk made a suggestion is just order her now today to return the first day of our next term. And then hopefully we can have all this sorted out by then.
Okay. I'll lift the benchmark your first day's when? Next time.
The first day of our next term is with you, it's on August the 29th.
Okay.
You're presiding there.
Okay. And I need her. Mr. Clean, you understand you gotta be back in here on August 29th if I let you out of jail.
Yes, sir. At this particular office, this general session, because I apologize, I'm used to going to Drivers.
Oh, you come here and see me?
I'm just not meeting you, Mr. Coleman.
I understand. You come in the back door of this courthouse right here at 9:30 on August 29th.
will.
Last Monday this month of August. Stay in touch with your attorney, he'll tell you when to come. Okay?
Yes, sir.
If you want to do me an order, I'll be glad to sign it, and you have to set up an appointment.
Thank you, Your Honor.
Okay.
This is Christian News TY. I'm Tony Conyers. Is there any newsworthy events in Williamsburg County? We will get them to you as soon as possible. If not, you can follow us on Christian News TY Facebook. You can follow us on YouTube, and you can follow us on our website.